Good afternoon and welcome to our annual settlement tutorial for both conservatorships and supervised estates. My name is Commissioner Misty Watson and I am a probate commissioner here in the 21st Judicial Circuit in St. Louis County. I wanted to go over a few things with you whenever you are preparing your annual settlement for either a conservatorship or a supervised estate. I know many of you have questions about Core 2 and filing those items once they are completed. I encourage you to review our other videos that we have posted in regards to Core 2 and how that can be addressed in those videos. Today, we're going to talk about the nuts and bolts of preparing an annual settlement. First, you should start with your inventory. Make sure it's correct and that no new assets have been discovered. Also, make sure that your inventory was accepted in the first place. Many times your notes have been made on your inventory and it hasn't been finally accepted because we're missing a legal description or an account number is wrong or something is incorrect on that initial inventory. If your initial inventory has not been accepted, whenever you are filing that inventory, don't file it under amended inventory. Please file it under inventory until it has been accepted. Once we've accepted the inventory, processed it, and issued an order accepting that, then at that point, if you need to amend the inventory, an amended inventory is just fine. But it's really important for purposes on our end, on the back end of things, that is properly titled that way. Whenever you're e-filing. How you title it, we don't care, but for e-filing, whenever you're picking the document type, you want to make sure to pick that proper document type. So what should the values be of your inventory? As stated on our website, the inventory value should be either the date of death values or the date the conservator was appointed, or the closest bank statement that you have to that. And I'm talking like if they were appointed on October 15th and your bank statement ends on October 20th, you're fine to use that October 20th bank statement. Your settlement should only include personal property and not real estate unless unless the real estate is sold in that same year. So again, for the purposes of the inventory, you're going to go to our stlcountycourts.com forms, probate forms, and you're going to be able to find the forms that you need in order to fill that out. So you can use that inventory and appraisement form. We highly encourage you to do that. So you click on that, it pops up, and then the next thing you need to do is click this little download button. Now I'm using Chrome. It may look a little different depending on what your web browser you're using, but you want to click that download button. And the reason why is because it's really important for you to be able to save this document, okay? And if we don't quite do it correctly, then you're going to have some issues, okay? So then you want to make sure that once you've downloaded it, you're opening it up in your desktop Adobe application. As I've talked about before, I think that for the practitioner, it's really important for you just to go ahead and get Adobe and spend the money to do that, especially for redaction purposes. And so this is your initial inventory. You're going to fill that out and make sure that you include all that properly, all of that information in there properly, okay? So just have that inventory, fill it out, make sure it is signed and notarized. That's really important that your personal representative or your conservator sign it. If you have two personal representatives and two conservators, they must both sign it. It is not an or for those things, it is always an and. So they must both sign this document and both have it notarized in order for us to accept it. So please make sure that you're doing that as well. So then you have your inventory, move on to your annual settlement, okay? So your annual settlement, again, you're only listing personal property, okay? So again, you're going to go over to our website you're going to find the annual settlement form, which is actually almost at the very top. It's the second form available on our website, and you want to download it out again. So you're going to click, and then you're going to hit this little download button right here, and that'll make sure that you actually have that settlement. I recommend that you do this each time and don't just pull up something that's in your forms folder, because we do update these from time to time. So it's really important that you do that. And this is what you're filing when you're not closing an estate. So if you have a supervised estate and you're not ready to close it yet, this is what you'd file. Of course, if you have a conservatorship, this is also what you would file each time. So this is your annual settlement. The first thing you're going to have is the balance of your personal property from your inventory. So you're going to look at your inventory and use that value. So let's say your inventory value was, we'll just say $25,000, okay? That was the value of all the bank accounts and everything else, okay? And don't round, you're using exact numbers here, okay? And again, don't include the real estate. Now, if this is not your first annual settlement, you're going to use the last annual settlement that was approved by the court for that starting balance, okay? And then we're going to act like this was from August of last year. And we're going to enter in our transactions, okay? Now, I personally like to divide up my transactions by bank. So let's say that the first bank that I have an account at is Enterprise Bank, okay? And I'm just going to put here exactly what account I'm referring to so that it makes it life easy for the auditors. Our goal is always to make things easy for them so that they can read your roadmap, okay? You're drawing them a roadmap. So on August 1st of 2022, I paid the bar plan bond premium, okay? And let's say that was $100. Okay, the other thing I want to do is I want to tell the auditor what authority I had. So here I have, you know, local court rule 72 approved. Okay, because local court rule 72 says you can pay bond premiums in conservatorships and in supervised estate without approval of the court. Okay, the next transaction I'm going to have, I haven't done much because we just opened the estate. So I just got my interest payment, okay? Interest earned, and we earned $5. And that ends my August statement. Then I'm going to move over here to September. And let's say that my award is over here at Del Mar Gardens. So I'm going to pay their room and board, okay? And I'm going to pay $5,000 for that. And then I'm going to tell them under what authority. Court order dated August 15, 2022, okay? Because you want to have a court order before you make a payment. If your client is making payments without court orders, then you are, violating the statutes, and you want to make sure that you have court orders for every single payment that you're making. So it's really important that you do that ahead of time, especially for your fees. There's actually, in one of our last CLEs, we went over that you may not take an attorney's fee without a court order, okay? So you may not be paying yourself monthly from this. So you would just keep doing this until you reach the end of that account, okay? And then let's just say your next item was your fidelity account. And again, you're welcome just to use the last four, okay? You don't have to give us the whole account number on these. So we're going to go through your fidelity account number, and again, you're just going to pull your statement, you're going to look at it, and let's say, that on August 31st, we had a dividend paid on AT&T, and that again was $6, okay? So you want to go through each statement, say what your dividends were, and then at the very end you want to do your gains and losses so that that can also be seen as appropriate, because you want you want this to balance to the statement at the end. Okay, so it's really important for you to be able to do that. And so you want these transactions to continue from the date of the inventory all the way up until the anniversary of the issuance of letters. Now, I get it. Each bank may give you slightly different statements. And it's okay if one statement ends on August 20th and another bank ends their statement on August 31st. Just end those each on the date that the statement ends. You don't have to make sure everything goes through August 31st. I always did that as a practitioner, and apparently I made the auditor's life a little more difficult for that. Now, along with having these expenditures, each expenditure should also have a voucher. So here I put voucher number 1. For my Del Mar Gardens, I'm going to have voucher number 2. And I'm going to take these vouchers and I'm going to attach them as exhibits to the bank statements. Okay, so you're going to take those vouchers, you're just going to physically attach them to the bank statements so that when you scan those in, it's all scanned in together. And each voucher should show that this item was paid and what it was paid for. So your voucher should match the amount you paid. And if it doesn't, you should be explaining why. And then if canceled checks are not included with the bank statements, you need to get copies of those canceled checks. So here's just a practice tip that I have. For one thing, establish estate accounts at banks that you have a good relationship with. Okay, you do not have to keep the estate account, and when I say estate account, I mean either conservatorship accounts or a supervised estate account at the bank where either the protectee banked or where the decedent banked. It's not a good idea to keep those accounts there. You want to have an account with a bank that you have a good relationship with as the counsel, and be able to have that account where you can have the ability to have information on it. You don't want to be a signer on the account. You don't want that responsibility, but you do want to be able to get information with your client's permission, of course, for those. And if you're dealing with a bank, maybe that's a bigger bank or something like that, it may be more difficult for you to get that information. So that's just a little practice tip. That account does need to be an interest-bearing checking account, so you want to make sure that it's an interest-bearing checking account. You want to make sure that that account does provide copies of the checks with the statements. It's just going to make your life easier. You also want to have that account at the time that it's established. Make sure that they send a courtesy copy of all the settlements, of all the statements to you as the legal counsel. So it's really important that you have all of those. That you can call and get a live person to talk to. And most of the small local banks will be able to handle this. Now, you do also want to make sure that your account's under the FDIC limit that is applicable to your situation. You may be able to get, $250, $500, it just depends. You also need to make sure that your bank account is properly titled, okay? So the bank account needs to say conservator, not custodian, not trustee, and it needs to have all of the conservators' names on it, okay? So if you have co-conservators, they both need to be listed on that bank account as conservators for the protectee. That's really important. Everybody's names need to be properly put on that account. I know some banks, that's an issue. But you want to make sure that you have that on there the way that it is properly done. In regards to income that the protectee is receiving, if it is Social Security or VA funds and the person is representative payee, you want to make sure that you file a motion for us to remove that representative payee income from the requirement for that to be accounted for, and then provide us with proof that somebody else is representative payee, whether that is the conservator themselves, but that there is a representative payee on that account. because then you will not need to account for it. If there's not a representative payee, then you need to account for those funds within the conservatorship. Now, it's really important once you are filling out your recap, that recap should match the amount that is your final balance, okay? So your bank statement should show an ending balance of $19,911. That means down here, whenever I'm typing in the bank account, it should be 19,000, see, I already forgot what it was, $911, okay? And that should be what's on the bank statement. Everything should match exactly what we have in regards to that. So we want to make sure everything matches and that we've got everything down there, okay? And then once we have all of that information, then we'll be able to get that. A lot of people don't know you can put the zeros there and then it'll add up for that. So again, this amount should match this amount, okay? So your balance and your recapitulation should match each other. Just a few other things. Whenever you do file these documents, make sure for any of these exhibits or bank statements, you're filing those under financial documents so they come in at a level 3. You also want to make sure that you are filing your proof of bond. So make sure that you file the proof that the bond's been paid, that it's still in effect. That's a big one people miss. Another thing people frequently miss is if the protectee does not have the right to drive, you need to have a petition to either sell or retain a vehicle. Remember, you're not supposed to sell or anything without a court order. So you do need, if you're going to sell something, you need to ask court permission. And there may be times we require notice out to them, depending on the protectee's level and ability to understand the situation and what's being sold. So we may even require notice out to them. Certainly on sale of real property, we're going to require that unless you make an allegation that they're not able to understand that. So you need to get court permission to sell that real property before you do it. Once you get court permission to sell the real property, then you're going to file a document, the report of sale, once you have a contract. Then it's going to be another 10 days before we can approve that report of sale. So I have a lot of people call up to the court and say, oh, we are supposed to be closing tomorrow, and they're saying we don't have a court order to sell the real property. Well, it's most likely I'm going to need to set that for hearing. And so we're going to need to set it at least 10 days out at minimum. And then once we issue the order for the sale of the real property, if it's appropriate, then you're going to have a report of sale and have that sit there for another 10 days. So please make sure that you've thought of that from kind of the beginning of your estate. Also, I have a lot of attorneys that come in and say, well, my client didn't do the settlement. This is on you. Okay, I expect you to be the one completing the annual settlement. I get it, clients don't always get you the information you need, but they should be being provided with a list of the information that is going to be needed. Honestly, whenever I was in private practice, I always held the checkbook and got the statements on a monthly basis and updated it every month so that I didn't have an issue at the end of the year whenever I was trying to get everything together. This really allowed things to be a lot easier, and of course my staff made my life a lot easier in regards to that. So those are just a few tips and tricks for getting your annual settlement approved, and thank you very much for taking the time to listen today. Take care.